So let me first start by introducing Jina Choi. She has been a key part of this conference since it started in 2014, originally here in her capacity as director of the SEC San Francisco Regional Office, where she was on the staff for over 16 years. Today, of course, she's a partner at Morrison Foerster in San Francisco, where she represents public and pre-IPO companies, financial institutions, asset management firms, boards, and much more. Welcome, Jina.
Thank you.
Also delighted...
Please hold your applause.
Always delighted to welcome Michele Layne. She's also been with us every year since 2014. She is the regional director for the SEC's Los Angeles office, and she served at the SEC since 2005 and has led the LA office since 2012. Under Michele's leadership, the LA office has produced some of the agency's most significant cases, and it's always a highlight to be able to work with Michele on this conference. Welcome, Michele.
Thank you.
Randall is a partner at Cooley with over 30 years of experience in both government and the private sector. He is the former regional director for the Pacific region of the SEC, where he was the SEC's top official in 9 western states, including California. He was also the first Asian American ever to head an SEC regional office. Randall also previously served as an AUSA in the U.S. Attorney's Office in Los Angeles, and he was also deputy chief of the major fraud section. Welcome, Randall.
Thanks, Bruce.
Our moderator today is Craig Martin, partner at Morrison Foerster. Craig represents issuers in SEC and DOJ matters involving allegations of accounting fraud and reporting failures. He also serves as personal counsel for executives and directors in government and internal investigations and advises audit and special committees. Craig previously served as an attorney in the SEC's Enforcement Division as well in San Francisco. Welcome, Craig.
Thanks.
Finally, delighted to be joined by Monique Winkler, the regional director of the SEC San Francisco office. She joined that office in 2008 and served as a member of the Public Finance Abuse Unit from its formation in 2010 until August 2019. Monique, thank you so much for joining us. Welcome. Let me turn over to Craig.
Great. Thanks so much, Bruce. So I'm gonna start with Michele and Monique. We've heard a lot about commission priorities and protocols. But this is, after all, Enforcement West, and we want to hear what's going on in LA and San Francisco. I was wondering if you could talk a little bit about priorities for your respective offices and any accomplishments that you'd like to talk about from the last year.
Sure. So first, I'm going to give the SEC admonition on behalf of Monique and myself, which is the views we express today are made in our official capacity as the respective regional directors and don't necessarily reflect those of the commissioners, the chair, or other commission staff. So with that, our office was very busy last year. We actually filed about 10% more cases than we had done in fiscal year 2021. We, like you've heard, like all the other offices, really cover the waterfront. We've had a lot of advisor cases. We still have a lot of offering fraud cases, market manipulation, a couple financial fraud disclosure cases, so really just everything. We also have several of the units have a presence in Los Angeles, so we've been involved in the crypto space, market abuse, cyber, and FCPA. And just a couple cases to highlight from the last fiscal year. We brought a disclosure and auditor independence case. The financial fraud case, disclosure case was against Michele, and then we brought the first ever independence action based on a human resource issue under the the independent audit standards against an audit partner at the auditing firm. We also brought a case, an insider trading case that was orchestrated by 2 employees of a newswire house that had been, the individuals were trading in advance of numerous press releases that were going to be issued by public companies announcing favorable or unfavorable results, depending upon which side they were on. And we also brought a number of cases just recently involving some violations by a variety of issuers for violating Regulation A. So I think those are just examples of the different areas that we continue to be very active in.
Great. Thanks, Monique.
Sure, thank you. Like Los Angeles, San Francisco had a very productive fiscal year last year. I think setting aside the sweeps that have been talked about, we filed more cases than in at least a decade. So the office really had a fantastic year. With filing a variety of cases, we have multiple units and cases represented in our office. We have CACU, PFAU, market abuse, and asset management. All the units filed cases. Highlighting a few cases outside the unit, we filed a case against several Charles Schwab subsidiaries, a case against an entity in Oregon called S-Ray, and then a couple cases, Headspin and Granite, that I'll discuss in more detail, I think in response to another question. And then, Craig, I'm not sure if you got onto priorities, but maybe I'll talk just a little bit about priorities. I think, of course,
Please.
San Francisco shares commission and division priorities, but also we always work to cover our region. I think we've done that in the past year, and we continue to sort of strive to cover everything from Silicon Valley up to Alaska. And I'll just mention, I think it's been mentioned before, sort of now more so than ever, speed is definitely a priority for our office. There's probably a few of you out there that have been affected by our quest for speed, and I think you'll continue to see that. And then just quickly, I want to mention a few leadership changes in San Francisco. So I think when I was sitting here last year, I was actually the acting regional director, slightly terrified, slightly less terrified this year. But we also have new heads of our exam and enforcement program, two long SEC staffers, Layne and then Jason Lee, who you heard from earlier today. We have several new assistant directors in our office as well, two of whom have spoken or will speak here today, David Zhao and Rahul Kahatkar, and then also a new assistant director, Chrissy Phillip.
And if I could just add some personnel updates in the LA office. So I think mostly probably everyone here has worked with Alka Patel, who was one of the enforcement co-heads, along with Kate Zolads, who you heard from earlier today. And Alka, after a long and distinguished career with the LA office, including 8 years as the co-head of enforcement, retired last month. We also have a new regional trial counsel over the last several months, Gary Leung, who is going to be a panelist this afternoon, and he has been with the LA office for about a decade, first as a trial counsel, then as an assistant director in the asset management unit, and most recently heading up our very busy and ever-growing trial unit. And then the head of our examination program is Cindy Eason, who has been in the role for about a year.
Great. Okay. Thank you both. So let me, Michele, good news. 2 weeks ago, the COVID federal emergency was lifted.
And how did I get COVID 2 weeks ago, living
Don't blame me, Michele.
So Jason earlier gave us a little look into how things are running in San Francisco, and I wanted to ask you, how hybrid are you in LA these days?
So I would say we're pretty hybrid. So I think, as everyone knows, we returned to the office a couple months ago, and so folks are required to be in 2 days a pay period. Most people are in more frequently than that, but a lot of the internal meetings and some external meetings as well continue to be done hybrid. So it's an adjustment, it's the new way of the world, I guess.
And since the COVID restrictions have been eased, have you noticed any changes either in terms of the pace of the investigations or the way that the investigations are being run out of your office?
Well, to Monique's point, there is a large emphasis, as there has been for a very long time, and it's good to always renew it, just on moving the investigations as quickly as possible. Justice delayed is justice denied. And, obviously at the beginning of COVID, things slowed down for everyone. But I would say over the last 2 years, the pace has really picked up. And the difference now is there's much more opportunity to just do things where everyone is in person.
So Jason talked a little bit about in San Francisco, the staff has a lot of discretion in terms of whether a particular meeting or testimony is going to be held in person or done remotely. Is that the case in LA? And if so, do you have any advice for those of us who would prefer to have an in-person meeting to make that happen?
Okay, well, again, this is my personal view, but I personally believe in-person is the most effective, and nobody will convince me otherwise. That being said, we do what's in the best interest of any particular case and what makes sense. So I think the presumption is Wells meetings, testimonies are done in person. There could be occasions where perhaps due to a travel schedule, et cetera, of defense counsel, everyone to be in person, they tell us will take several weeks, and if we could do it next week remotely, that would be taken under consideration. So we try to be flexible, but obviously the most important thing is to do what's going to be most effective in pursuing the case.
Yeah, I agree with Michele. I mean, I think historically, whether intentionally or not, Wells meetings is a really good topic where it seems like they were used for delay. I mean, we could be having a call with somebody and they would be telling us today they wanted their Wells meeting in August, and you're not going to see that happen. And if we can't get everybody in the same room in the next few weeks, we're going to do it in a hybrid way. I mean, we're flexible. We want to meet with you in person, but if it's going to cause delay and be detrimental to the work that we're doing, you're probably not going to have an in-person meeting.
So, Randall, you are a well-known people person. Well, how are you batting in terms of getting meetings in person with the staff?
Yeah, I don't know why all of my requests for in-person meetings get turned down. No, I'd be curious how recent the presumption is that meetings will be in person, because I have to say my experience, including quite recently, has been real resistance, at least in some cases, to in-person testimony or in-person meetings. And, I've gotten the line sort of like, well, I mean, if you have a particular reason you think it needs to be in person, let us know and we'll consider it. But otherwise, remote has worked fine for the last 3 years, and we'd prefer to do it remote. So, I know there's discretion among staff, but the issue is not whether remote works fine. Obviously, we've all gotten used to doing things remotely for the last 3 years. The issue is really, is it better to do it in person? And I think from my perspective anyway, it is almost always the case, other than something that's quite routine, that I would prefer to be in person. And from our client's perspective, I had a case where the client, his testimony was taken remotely. He was charged and eventually settled the case, but I think he felt like he never really got a full opportunity to sit down with the people who were making the decision to bring the case against him, because it was all remote, and he never had that face-to-face interaction. So I think that's just another element to think about when deciding whether to do something in person.
Great. Okay. Well, let me change gears here and talk a little bit about the criminal side of the house. And we heard earlier Randy was talking about the fact that Izzy is our new U.S. attorney here in the Northern District. And Randy predicted, I think it kind of boiled down to two things, that Izzy was not necessarily going to increase the number of white-collar cases in the Northern District, but that he was going to be more successful in terms of preventing poaching from other arms of the Justice Department. Of course, Izzy is not our only new U.S. attorney. We've got 3 new U.S. attorneys here in California, and then more as you go up the coast. I wonder, Michele, Monique, if you all have a prediction in terms of the appetite that these new U.S. attorneys are going to have for criminal referrals.
Well, at least from my perspective, we work with U.S. Attorney's Office and Main Justice on a lot of cases, but the primary U.S. Attorney offices that we work with are the Central District of California, the Southern District of California, and there has been no change. White collar, securities, corporate crime has been a high priority for both those offices over the last number of years, and we continue to have numerous parallel investigations with both of those offices as well as with Main Justice. So I haven't detected or noticed any change. There's certainly no back or lesser of a priority, so it continues to be a really high priority area.
Yeah, I haven't noticed a change in the Eastern District or the Northern District either. As many of you know, we have several former SEC staffers at the Northern District that definitely are good partners that we work in parallel with, and I don't anticipate anything is going to change under the new U.S. Attorney.
The potential for something to go criminal obviously has a huge effect on how a defense attorney is going to handle an SEC investigation. Do either of you have any hints in terms of how we might be in a better position to predict whether something might go criminal, whether there could be a referral?
Well, I mean, it's a spectrum, right? So I would think probably defense counsel is in the best position to identify, knowing all the facts at the get-go or sooner perhaps than the government, whether something might rise to the level of criminal interest. And it really varies, right? There's cases that we open, that the U.S. Attorney Office, the FBI open on a press report, on an informant, a whistleblower, et cetera. And so some of those are obvious that the crims are going to be interested in, and others, things develop during the course of our investigation that suggest it might be of interest to the crims and vice versa. But I think, it behooves everyone to be aware that, there's constant communication among the offices and what's in the pipeline and trends and particular matters that are discussed at a high level.
So Jina, do you feel like you're in the best position to predict whether something's going to go criminal after a consultation with the client? And if not, what do you do? What would you recommend for practitioners to get a better understanding of the direction things may go?
I do think it's really important for those of us who practice in this space to be very aware of the relationships and the dynamics. I think what Michele and Monique are talking about, that there is a good relationship, a constant flow of information between the two offices is something to keep in mind and to make sure that your clients are not surprised by anything. I think that I think the defense bar up here in the Bay Area is heartened to know that some of the local prosecutors have deep roots in the community, are seasoned public servants, and I think we all believe that they're not in the positions they're in to make a name for themselves. Which I think is really important. And I think they know the difference between what is a criminal case and what is a civil case, and that resources are scarce. One thing that I think goes into our thinking, though, is the SEC consults with many different offices and can bring their cases anywhere. And that's something to always keep in mind. I think that it's good to hear that Izzy and some of the other prosecutors believe that conduct that happens in the Northern District or the Eastern District or the Central District of California are prosecuted in those districts, but I think there's also other prosecutors who generally tend to come to California and like to prosecute those cases, and it's always good to keep that in mind.
Okay. Well, I'm going to change gears again and talk about settlements and cooperation. And we've had a lot of discussion about that today. Many of the panelists have talked about it. And if I were to boil it down from the defense perspective, I think that the message has been that the commission's actions, orders on settlements are fractured. And sometimes it's hard to discern what it is precisely that the commission is asking in order to effect cooperation. And at the same time, the benefits of cooperation are dubious, and in that clients continue to get sued. In many cases, cooperation is touted by the staff, but also there's a significant penalty. We also heard from the staff that, however, that pointing to recent matters that articulated the factors that the staff considered, as well as a reduction in penalties, and Ansu also pointed out that if you're not cooperating, you're not going to be part of the conversation either about the evidence or really about a favorable outcome. Taking all of that into account, we did see recently the guidance that came out of DOJ, where with self-reporting, with cooperation, and with remediation, there's a presumption of declination. And one could argue that that's maybe a much more simple, straightforward way of looking at that. And I wonder, Michele, whether you think that the commission might adopt a posture like that.
So I would think not. And as we were talking about this in one of our prep sessions, bringing a civil action against a corporation is a very different situation than bringing criminal charges. And so I think in light of just the dramatically different consequences give rise to different approaches. So I think as Gerbert just mentioned in his conversation with Kristen, the seaboard factors, as he said, they're, now of drinking age. So it's no secret what the elements of cooperation are. And it really is a fairly common sense analysis. What I can understand is there isn't a specific delineation of the company cooperated in the following ways, and therefore a penalty that might have been assessed in the amount of X is now being imposed in the amount of Y in light of the cooperation. But the essence of it really is there. And the main benefit for companies who cooperate and follow the guidance that's articulated in the Seaboard report is you do get substantial credit for the penalty.
And thank you. And Monique, maybe you've got some other insights you could point to, or some representative cases.
Sure. And I think I agree with Michele said. I mean, to boil it down, I don't think it's that complicated. I mean, I think many of you are looking for something that's going to allow you to go to your client and say, if you do X, your penalty is going to be Y. That's just, it's not going to happen. But what you need to do is out there. It's something more than responding to a subpoena, and then it's nuanced after that. And before I talk about the cases, I do want to suggest, because I actually think this has happened once in the 15 years that I've been at the SEC now, and there's no harm in just asking the staff attorney, do you think I'm doing a good job cooperating? What else do you think I could do? The staff attorney is not the commission. They're not the ultimate decider, but I think they're going to be able to give you a pretty good assessment of where you are in your cooperation. And I think two cases came out of our office this past year that gave some details on what sort of cooperation credit is out there and what it might get you. And one of them is a case called Granite Construction. In that case, the SEC charged the company and a former senior vice president with fraud for inflating the financial performance of a major subdivision of the business unit that the senior vice president managed. The company did end up paying a penalty. It was $12 million to settle the SEC's charges. The senior vice president is litigating. But of note here, the complaint credits Granite with self-reporting to the commission, so there's one factor, undertaking remediation by, among other things, redesigning its internal accounting controls and policies and procedures to increase the transparency and accuracy of expected costs for construction projects. Obviously, that's very specific to the company and the industry it's in, but I don't think it's that hard to translate that to a different entity, a different industry. And another example is the Commission's January 2022 case against Silicon Valley private company Headspin. In that case, the SEC sued the company and its former CEO for fraud, alleging that the former CEO falsely inflated key financial metrics and doctored internal sales records. As the Commission alleged in its complaint, the company's board of directors conducted an internal investigation, forced the CEO to resign after they determined that the company's annual recurring revenue was significantly different than what the company had represented to investors. The company also repaid substantial funds to investors, hired new senior management, expanded its board, improved its accounting processes and procedures. And there, the company actually didn't pay a penalty.
And, another area that I would just highlight for some of the advisors and other regulated entities, when the staff can seek, as part of the relief, an independent compliance consultant, which we know can be expensive and firms generally are reluctant to do so. But when a firm has engaged in a lot of remediation and dealt with the other factors identified in Seaboard. That is also another benefit to cooperation, where you might not get that request from the staff as part of the resolution of the matter. And as a lot of you have seen in the FCPA context, where again a firm has cooperated and remediated, then there often are occasions where the requirement of a corporate monitor being included, that's obviously on the DOJ side as well, but it's not just the penalty, it's other relief that can be very impactful on the entity that is also available when there's a lot of cooperation.
Can I jump in?
Yep, please.
So I think a couple of thoughts. Number one, I think to a large degree the Commission, in describing these issues, sort of conflates 2 points. Number one, what constitutes cooperation? And number two, which is a separate question, what are the benefits of cooperation? And I agree, the Commission has done a better job recently in describing whether a company has cooperated and what the company has done to warrant being commended for its cooperation. But I think from my perspective, the question of what is the benefit that the company actually got, it remains a black box. And I think those are two different issues. It's very, it's somewhat easy to say, well, look at Seaboard, but Seaboard doesn't answer any of that. Seaboard is basically, Seaboard is from 2000, and it is basically a laundry list of questions to be asked that go through the various components of cooperation. It really says nothing about what the benefits are. So that's point number one. And then point number two is, of course there's a difference between DOJ and SEC ramifications or consequences, but DOJ has seen fit to promulgate, very detailed guidance with much more concrete sort of markers of, what the benefit could be, what the consequences could be, and so on. And sure, there remains a lot of unanswered questions, and there remains enormous discretion in the hands of prosecutors, but at least there is more guidance, and I think more guidance is always less, and I just don't sort of follow the rationale that, well, our consequences are only civil, therefore we're not going to give you more guidance.
Just to kind of build on the conversation here. I do find the, if you look in the orders now, as Randall was mentioning and as Monique and Michele set forth, I think the commission did hear a lot of the defense bar's issues, like what constitutes cooperation. Now you'll see in the orders, there's a little section that says cooperation and remedial efforts, and you can kind of tick through them. I think that's great for the defense when you're representing companies, entities, advisors. At the same time, I do think this idea of what the actual benefits are. I think you heard this morning from some folks who are in-house. I think they are a little skeptical. And I think that the idea of kind of changing and calibrating the penalty amount is kind of using one tool, probably the easiest tool, but the idea of actually not bringing a case against an entity that has, changed its leadership, that has set forward on a new course, especially when you consider some of the extraneous issues that come with a case, even when there is no penalty. And I'm speaking of a lot of the capital raising elements, like the bad actor provisions and the ability to raise capital. If you have a case against you, regardless of what your penalty is, I think that can be a very difficult situation for issuers. And I think it's even more difficult right now because I think the guidance has changed a little bit in the last few years about what an entity can expect in that space.
So up until a couple of years ago, one could submit a settlement proposal contingent on getting a waiver from Corp Fin under those bad actor rules, which have implications for individuals or companies who face disqualification. How do you navigate that when now in the current regime where that's an issue for your client?
I think it's really difficult because I think that the staff's hands are very tied. The enforcement staff's hands are very tied about what they can project, what issuers can anticipate, and I think it is kind of all. I think what the staff can control is the charge against the issuer. So I think in that. It makes it, what we're talking about here is a lot of discretion on the part of the staff, but also their tools. And I feel like the Enforcement Division has chosen to use the civil monetary penalty as their main tool. And so now, the penalty amounts have gone up profoundly. And now then there's discretion on being able to pull that back in cases of cooperation. But, maybe we could use some of our other tools, because some of the tools are like SOX 304 clawbacks, actually bringing a case or not. I think there's a variety of tools, admissions, things that the staff can use, and it'd be great to see the staff be able to use more of those tools and show discretion.
Great. Okay. Well, on the subject of settlement, so Michele, last year the commission required admissions of misconduct in 19 cases, and the vast majority of those were in the broker-dealer record-keeping suite. But there were others. There was EY, there was Allianz. And I wonder what lessons defense counsel can learn from any of those cases. So often by the time we're brought in, it feels like much of the cake has been baked, if not burnt. And so coming in late, on the scene, are there things that we can do that we can help our client with to avoid such an unfortunate outcome?
Well, great question. So I think before answering it, though, just to reiterate the criteria that was laid out by Mary Jo White 10 years ago in the Commission's original admissions policy, still serve as the governing factors today in the staff's analysis of whether or not a matter might be appropriate to seek admissions. So there are cases where a large number of investors have been harmed or the conduct was otherwise egregious, where the conduct posed a significant risk to the market or investors, where admissions would aid investors deciding whether to deal with a particular party in the future, where reciting unambiguous facts would send an important message to the market about a particular case. So I hear and respect your question, Craig, but I think part of it is the decision really, I don't know how much it can be affected by what defense counsel does, to the extent that admissions really aren't a measure or impacted that much by cooperation. Because, for instance, if the conduct itself met a lot of those criteria, but you come in and cooperate and remediate, the cake was baked, the misconduct occurred, and if it really falls into those criteria, admissions might be appropriate to serve the larger deterrent purpose. But that being said, we also could consider admissions in cases involving obstruction of the Commission's processes and where admissions would greatly amplify the deterrent effect of the action. So I think the E&Y case is a prime example where admissions were sought and obtained in that matter, which I think most folks know it was like the largest ever $100 million penalty imposed against an audit firm. And the underlying violation was there was a lot of cheating by numerous professionals at the firm in their certification and continuing education to retain their CPA license. But another significant fact in that investigation is there was obstruction of the enforcement staff's investigation. So I think when you have, gatekeepers who are charged with upholding themselves to a high ethical standard are cheating, that's not a good thing. And then when you add the layer of the obstruction, I don't think it was shocking that that case had admissions.
It's interesting, don't you think, Craig? Like, I feel like admissions were such, like they were earth-shattering when they were first announced with Mary Jo in 2013, 2014. And I feel like they've become much less of an issue now. And I wonder if I do think it can be very helpful for the staff to be able to point to cases of extreme conduct and show those admission cases. But, so I don't think of those necessarily as a tool like that and I don't know that that's appropriate for the staff to kind of hold it over a defendant's head, and if you don't cooperate, if you don't get this if you don't act what we see as an appropriate way, we're going to force you to take admissions. That's probably not appropriate. But what do you think about 304? Like, is that like a discretionary tool, or is that just something, hey, we're just going to seek it every time, no discretion, we're not going to negotiate that?
I mean, I think we're going to seek it in most cases where we can. I mean, it's a really important remedy. A lot of the Commission as a whole feels very strongly about it. And I guess I would ask, why wouldn't we seek it?
So it's not really a tool. It's not like seen as that. It's not seen as something like a lever that can be used to incentivize extraordinary and exemplary cooperation.
I mean, I personally wouldn't see that as on the table. In my view, it's like disgorgement. We don't negotiate the disgorgement amount. Like, the ill-gotten gains are what they are. Sometimes they're a compromise where the calculation of what the net ill-gotten gains are, but disgorgement has never been negotiable as like, well, you've cooperated, so therefore we're going to give you a 50% credit on the disgorgement. It's an ill-gotten gain. It's an equitable remedy. Like, in what world does a wrongdoer get to keep their ill-gotten gains? I can't think of a compelling reason why. And under SOX 304, if you got that incentive-based compensation during the relevant period, what's the rationale to not repay it?
Even though there's no wrongdoing, that's not a wrongdoing.
Right, well, there is no wrongdoing necessary by the former CEO or the CEO or CFO.
Right, it's just a windfall that they should return.
Yeah, I mean, there's a long legislative history about what gave rise to that rule.
I guess, so one more thing, I guess I'd just like to add, so then it does seem like penalties. Penalties are where that's our lever. And we've raised the floor on penalties. And so now we'll drop it a little bit for when you cooperate. But I'm just wondering, Kabir did speak a little bit about the idea of, and I've heard associates in DC, like I think at this similar event on the East Coast, 50% of my docket, I don't bring a case. And they don't necessarily publicize that. But the idea of not bringing a charge against an entity, versus that idea of we're going to bring the charge, but we're not going to assess a civil monetary penalty. I just wonder if that's that same instinct of like, we're going to bring a charge. Like, can we even kind of float that to our client? Like, if they can show these elements, no matter how much you cooperate, you're gonna have to take a charge.
I mean, I do think it depends on the facts and circumstances. And look, I mean, there aren't that many cases that are so black and white that, here's the evidence, we think it supports the charge, like summary judgment as soon as we can bring the case, right? So there's a lot of, how you look at the evidence. There can be like the jury appeal or not to a case that can factor in. So I think it all does go into the mix, but what I can say is how defense counsel and their clients conduct themselves during the course of an investigation go towards the credibility, right? So if there has been, game playing, delays, lack of candor in testimony, that goes into the total mix and the degree of skepticism and acceptance of representations that are made by the party. So I don't think I think it is always beneficial to be cooperative. Certainly, it is never beneficial to be obstructive. And as for the commission walking away because there was like perfect cooperation, if it was a case, that the evidence is very strong and that it was a significant violation in a priority area that had an adverse impact on a lot of investors, I don't think there'd be an appetite like, well, the company really cooperated and so we should walk away. Because there is a very important mandate to hold wrongdoers accountable for the integrity and confidence that investors have in the markets. I mean, that is part of our mission.
I hear you, and I don't want to belabor this. Okay. I just wanted to say, but just like if you look at Headspin, right? Headspin is a case that's like.
Remember when you were the regional?
But that's a case where it's an individual. You get the individual for 10B. You even criminally prosecute that individual for 10B. Like, is it necessary to bring?
Well, but by that argument, why do you ever sue a company? There's always an individual who is accountable. Hopefully, not always. Sometimes there's, corporate negligence.
I guess what I would love to get out of these folks
Monique, we're calling in the reinforcements.
More the idea is like, are you looking for that case? Like, can we hold that out to our clients? Like, you know what? They're actually looking for this kind of case where they can, refrain from bringing, like they want to make a statement here. And, depending on what you do post-conduct and how you conduct yourselves in this investigation and what you choose to share, Can we hold out hope, or is that not?
I mean, I don't think
Never happening, Jina.
I don't think DPAs and NPAs are off the table. I mean, I think that they're still out there. But I'm not operating under a mandate that I'm looking for a case to do a DPA or an NPA in, but it's not off the table.
Yeah. They're not endangered species, but they're rarely spotted out in the wild. I'm going to move to something less controversial here because I'm going to lose control of the panel, and I'm kind of half kidding. So
It's your partner.
So the SEC is litigating a subpoena against Covington and Burling now, seeking the names of clients who received notification that their information had been or may have been compromised. And that subpoena enforcement action has generated a lot of concern in the defense bar. There was an amicus brief that 83 firms signed off on. Jina, is the SEC coming for our client lists?
I really hope not. But I do feel like that case, when I read that case, just the subpoena enforcement, it does kind of, it did kind of take my breath away. And I think that some folks in this room might have been around when the San Francisco office, we used to call it Subpoena-gate, where they issued subpoenas to certain members of the press, and people were taken aback by that. So the idea that the SEC would subpoena a law firm, that just seemed really breathtaking.
So we are running very low on time. But Randall,
Well, I'm just going to add, I think there are really two questions. From a policy standpoint, I share the concern. I'm surprised that the SEC has decided to pick this particular fight. From a legal standpoint, I think it's a really tough case. And I have to say, even though this is not in keeping with my role as a thorn in Michelle's side, I have to say, I think some of the arguments that Covington and the Amici have made are pretty hyperbolic and sort of theoretical as to the dangers of enforcing this subpoena from a legal perspective. So I think it's a fascinating case, but I think it's a close one.
Okay. And so Michele, Monique, I'm going to give you
No,
guys.
let's end right there.
Michelle will never hear that again.
let me ask Michele, Monique this. There's going to come a time when a law firm is going to have information that's relevant to an investigation, and it may not have come in a privileged context, or it may not be privileged, or it just may simply be that they participated in some form in a transaction. And I'm just curious, when the prospect of sending a subpoena to a law firm hits your desk, what do you think about? And is it fine, anything goes, or is there an extra layer of consideration that goes into that process?
There is a great deal of deliberation, consideration, and consultation when we do that. That being said, we have had investigations where we have sought, either voluntarily or by a subpoena, information from a law firm, and at least in the matters that I've been involved in, like, we've been able to reach a good resolution, and we don't want the firm's privileged information. We need some of the facts that the firm has, and that is why they get the subpoena.
Okay, that's where we're going to end it, Bruce.
Thank you all. Great panel.